Hello everyone, welcome to the 140 Literary and Jury Charge. We're going to finish off our article that we were reading in the last class, and it is called Plight of the Grisly. Here we go, ready? Some 30 grizzlies, less than 5% of all their number left in the West, now wear radio transmitters. One, number 38, is a mature female who lives inside the bear habitat of the Yellowstone ecosystem, a tract of more than 8,800 square miles, about 1/3 of which is within Yellowstone National Park. Last year, Grizzly 38 and two half-grown cubs began traveling toward the Targhee National Forest in Idaho. On August 23rd, her signal was picked up by Dick Knight, a Yellowstone bear biologist who was patrolling in an airplane. Knight alerted George Matiko, a Forest Service range wildlife manager, who called Bill Inglet, a sheep rancher. Inglet had about 3,000 sheep on leased federal land in the Tyge Basin, a Situation 1 area. In these areas, the welfare of grizzlies come first, before the interest of humans. There are also Situation 2 and 3 areas in which, vis-a-vis bears, human interests are progressively upgraded. Inget had his two shepherds start moving the sheep to Big Springs, some 15 miles distant. However, number 38 and her cubs arrived and jumped the sheep on their bed ground. The bears were driven off by warning rifle fire, but during the night, two sheep were attacked and had to be put to death. On August 24, Inget, his sister Lori, and two nephews, Hal and Jeff Buster, joined the shepherds. Shortly, Forest Service biologist Brianne Franklin arrived looking for bear signs. For the next 3 days, nobody knew where the bears were, the weather having turned so bad that Dick Knight could not fly. On the 27th, visibility improved and Knight got a signal pinpointing number 38, only half a mile from the flock. That night, a lamb was killed. 2 days later, Hal Buster, on horseback, was charged by number 38, probably in defense of her cubs. Buster managed to escape. The Forest Service closed several nearby campgrounds and evacuated 2 of its own work crews, as well as some commercial loggers and sawmill operators. About 20 people assembled. Personnel from the Forest Service, the Idaho Fish and Game Department, and the Interagency Grizzly Bear Study Team. They were in disagreement about what should be done. Inget wanted the bears removed. The Interagency team argued that this was Situation 1 country. Forest Service operatives were torn between their obligations to the grizzlies and to Inget, in a sense their client. Idaho game officers who had bear handling equipment said they would use it when the feds, on whose lands the problem was occurring, made up their minds. A compromise was struck. Inget would continue to move his sheep, and Forest Service officials would cover his retreat. The bears were hazed by aircraft, and flares and propane cannons, noisemakers really, were fired at them. On several nights, Idaho Fish and Game personnel strung up a half-mile of electric fence around the sheep bed grounds. Still, the 3 bears found an opening and picked off a few more of the flock. The improbable entourage, herders, public servants, members of a video crew, sheep and bears, arrived at Inget's Big Springs Corral on September 4th. There, Ingot sold his lambs and drove the ewes and bucks back to his ranch 2 miles away. The bears followed. All parties then milled about for several days, and the grizzlies began touring private and federal lands on which their status was less protected than in Situation 1 areas. It was then decided that to avoid a serious incident or vigilante action by aroused local residents, the bear family had to be removed. 3 traps were set and baited. The bears roamed for about another day or so, but on September 9 were taken in the traps and trucked back to Yellowstone, except that the sow got a replacement radio collar and the cubs their first ones. The 3 bears were unmarked by their excursion. On the human side, the incident cost about $50,000. Grizzly number 15, an 8-foot-long, 430-pound male, was first radio collared back in 1985. He was in the Gallatin National Forest on the western edge of Yellowstone on June 24, 1993. Early on June 25, he padded up to a Forest Service campground where William May, 23, was camping with a friend. Without warning, number 15 ripped open the tent of the sleeping campers, picked up May, carried the screaming man 30 feet, killed him, and ate about a third of his body. There is a firm rule that a grizzly that kills a human without cause, not in defense of cubs, for example, has to be destroyed immediately. Grizzlies are very adaptive. If they hit on a tactic that works, they are apt to repeat it. On the night of June 25, number 15 returned to the place where he had killed William May and was caught in a foot snare lashed to a stout tree. The enraged animal began tearing at the trap and cables. A Montana game official shot a tranquilizer dart into the frenzied beast. When tests determined that this was the bear that had killed May, a legal dose of poison was injected. Okay, so we're going to stop there and we'll finish that up and then finish the rest of this article in the next class. Okay. All right, so I'm going to read you some legal terms and then I'll read you your paragraph. Okay, you're going to hear exchange, negotiable, instrument, tender, collateral, promissory, security, pledged, payer, note, legal, which is L long E-L for the brief, legal, draft, payee, exchange, and check. All right, here we go. Ready? A check is an instrument used to transfer money from one person to the other. Any form of legal tender must be accepted as payment. A bill of exchange is called a draft. A promissory note is a written promise to pay a specified sum on a specific date. Security that is pledged for a note is called collateral. The payee is the person to whom a check, draft, or a note is made payable. The one who orders payment is the maker. The one who pays the check, draft, or note is the payer. Okay. I've got a fun fact for the day. Okay, here we go. Why is the word seed used when ranking sports teams in tournaments? In 1898, the American Lawn Tennis Association, the major governing board of the sport, then called lawn tennis, was holding a major national tournament. Officials figured that the best way to disperse the top players and make things fair would be to scatter them like seeds so that they'd be separate and not play each other in early rounds. Interesting. I like to hear how those things come about. All right. I've got some legal opinion. All right, this is legal opinion. Here we go. I'd like to first advise the court that what is at stake on this discovery motion is not simply categories of documents, some 60 questions involved in Penwell's deposition. I'd like the court to know that there are 5 depositions and 5 document productions or requests for document productions, which are pending at this time in this litigation, awaiting the outcome of the court's ruling on this particular motion, specifically the deposition of the President, Coast Federal, Mr. Blakely, Executive Vice President, Mr. Martin, and 3 other executives or officers, Mr. Van Zost, McNair, and Stemler. I submit to the court if Huntington Center is wrong about the relevancy of all these collateral matters which they inquired into of Mr. Penwell. I think all of this information is a colossal waste of money and time on themselves and on these 5 other Coast officers. Mr. Penwell's deposition consumed 4 days. 350 pages, which I hold in my hand, are the product of the first 3 days. The 4th day, which was on April 1st, has not even been transcribed. So this is the dimension of the kind of discovery which the court is being asked to permit here. Now, with respect to documents requested for the purpose of ascertaining the intent of Coast Federal at all times that the lease was entered into in 2003. First of all, Coast Federal was not even involved in the lease transaction. One of its predecessors, Southern Federal Savings and Loan, was. There could be documents still in Coast Federal's possession as a result of acquiring Southern Federal by merger. The problem here is they never really tell us what particular intent they are after as far as the requested document production. The lease provisions that we are concerned with here are pretty much standard boilerplate kind of provisions. First, there is a standard covenant against subleasing and assignment without the lessor's consent. That is Article 15. We have Article 34, which says the lessor, whenever its consent is required, shall not unreasonably withhold its consent. Now, what conceivable parole evidence, Your Honor, would be introduced to give some kind of peculiar interpretation to these provisions? As the court can see, there is a boilerplate printed lease produced and propounded by Huntington Center in 2005. I don't see what all the documentation with respect to the negotiations of this lease is going to prove, and how that is going to resolve specifically the dispute which is before the court, which is the validity of this sublease transaction. The issues are, you have these 2 standard provisions, and what you do is you look at the conduct of the parties with respect to the requested subleasing. The fact is Coast Federal made the request in May. All right, what ensued thereafter with respect to assessments of the reliability and responsibility of the proposed subtenant and the conduct of both Coast and Huntington Center, which bear on the issue of waiver, estoppel, good faith. The point is, Your Honor, I don't believe that by any stretch of the imagination it is relevant to go back to 2005 when this lease was executed and start getting into everything that happened at that particular point in time. Okay, so we'll stop there. I'm going to give you some technical terminology. Technical terminology. Here we go. Okay, ready? All right, ready? Any language that you do not know can be termed foreign or technical. In other words, it is more difficult to write because you do not comprehend it instantly. Generally speaking, however, when we speak of technical terminology, we refer to medical, legal, chemical, or other language of the professions. A mathematician, for instance, can speak about the properties of mathematics. A nuclear scientist can speak for days about his specialty in language that can make it very difficult to report. The reporter does not have to be a doctor in order to write what the doctor says, or a lawyer to report what the lawyer says, and so on. The reporter must, however, become familiar with enough of the language of these and other professions so that the words can be reported with a minimum of difficulty and hesitation. Shorthand speed drops rapidly when you have to ponder what was said before writing it. The first thing to do is to learn as much about English and vocabulary as you possibly can. Take English courses. If you feel that you would like to further improve your knowledge along these lines, try to enroll at a local college or university to learn more about important subjects such as legal and medical terminology. Read books on anatomy, physiology, chemistry, engineering, and law. Some of the textbooks used by nurses or nurses' training schools are good references for the student reporter. The National Shorthand Reporters Association publishes a professional series of texts, including volumes on English, medical, and legal terminology. They are excellent sources of material for students. When you know that you will have to report a highly technical case or deposition, read as much as you can about that specialty in advance. You will have fewer surprises during the course of the case or deposition. Many hearings are being held concerning environment and ecology. These fields offer their own set of technical terms. The U.S. Environmental Protection Agency publishes a glossary of common environmental terms and can be had for the asking. It includes terms and definitions of most of the words and phrases that you might be expected to write when reporting an environmental protection hearing. Not everything you report will involve a so-called expert witness whose language will make you work harder. To be safe, however, you must assume that your future as a reporter will be peopled with enough expert witnesses from the various various sciences and professions that you should begin now to increase your knowledge about as many disciplines as you can. Okay, and that concludes our 140 literary and jury charge. Have a great day.